I'm CEO. The treasurer who has just been up here. The CEO. Our guest for today, Council Jude Byamukama, who is also our council, ULS council. George Musisi, my good friend and a colleague. Thank you very much for sparing time to come and speak to the members today about the various issues. As you are aware, we launched this R&B Live weekly update for purposes of connecting with the membership and other members of the public to remain relevant so that people do not question what we are doing, what is council doing, but we speak to the people. And also in the area of promotion or promoting rule of law, we keep discussing pertinent issues at a time, issues that are affecting the area of rule of law and justice at a time. That is why we thought this was one of those avenues we should have that. So I thank my colleagues, Judge Musisi, for clearly elaborating the issues. We've been seeing these things in the media, but when we have one of our own elaborating and answering questions, it gives hope to the members of the public out there who believe ULS should serve them, who believe ULS has a duty to fight for them. And that's what we do. That's what we shall keep fighting for. Now, if you notice from Council Jude's presentation, he gave us the status, the current status, beginning with an outcry from the candidates. One thing I believe everyone knows is that this whole aspect of having members or representatives to the Judicial Service Commission go through an election came through the Radical New Bar's policy of democratization. It has never happened. This is the very first time. And just as we expected, of course it would face backlash. The members or the representatives of ULS at the Judicial Service Commission have always been selected by the sitting president. But as the Radical New Bar, we felt it is wrong. We needed to respect court's pronunciation, democracy, and the Constitution, and allow members of the bar to participate in selecting who should represent them because of the significance of Judicial Service Commission, because of the load of the work and the responsibility they are tasked with. Unfortunately, that process was put on hold. We were supposed to have this on the 17th of December last year, which we felt should have been a Christmas gift to all the members of the Uganda Law Society. Anyone who loves democracy, any member of Uganda Law Society should have been proud of that. Now, it so happened that that EOGM was stopped. We had some overzealous members of the society whom I would say probably do not have, the treasurer talked about members who should love their society, running to court to stop this process. And just like you also had the treasurer give updates, and just like you had Jude talk about the governance issues, how we manage issues as council, we had three major areas of discussion. As the society, we need to learn how to run our affairs without involving other people who do not need to go to court to help us or to guide us on how the society should be run. We should be independent. If you are saying we want to talk about the independence of the legal profession, we should depict that. We should be able to run our affairs, manage our affairs without involving outsiders or people to decide for us. And someone was asking, how did we get here? How did this all begin? You had council explaining, and of course, like we're saying, it's a governance issue. It started when we saw the elected secretary, Munabi Philip, issue erratic statements to the public that is dismissing the president and myself from council. And that is something we should be able to manage on our own. We don't even need to run to court to get a solution for that. And of course, as the majority of council, we sit and make a decision. We think this is something, because of that conduct, the membership to whom we are accountable, because we are accountable to the members who voted us into office. should be the ones to handle this issue. Pending that, we felt as council, through a resolution, these erratic members, that is Munabi Philip then, and the central representative, should be suspended pending the EGM, where all these matters should be discussed. Members should be allowed, the membership should be allowed to participate in the governance issue. They should discuss that issue. So we felt we need to have an EGM to discuss that, the issue of governance and the behavior of some of us, members of council. The books of account, the treasurer is giving us piecemeals of how we found how the status of the society's books or finances, which should have been done at that time. And also the most important, the voting for the Judicial Service Commission, which all was put to a hold, like I said, by some members we feel do not have any love for the society, because that should have been the only solution. I still believe that EGM or the EOGM or a meeting of the members should have been the solution for whatever is happening, be it a governance issue, be it whatever. But that is how we ended up here. Now, I want to assure the members online, those who are here physically, that we do take our mandate very seriously. We don't sit in these offices to serve our own interests, but rather the interests of the membership. And we must take that with humility. We must do what we're supposed to do. Of course, pending or after the decision of court, you saw again other actions. Earlier today, I did issue a statement concerning that, the actions of some of the members. We all know that in the court's decision, Justice Sekana stressed that whichever decisions we should take, they should be taken as council. Even if the secretary is to call for a meeting, it should be in consultation of council. But then again, like Jude said, before we got to that point, we had tried avenues of, amicable settlement and having this out of the way for the benefit of the society and the good of the membership. Unfortunately, that wasn't done. And we still have the same members who still want to frustrate this process. That was the reason I chose to issue a formal statement, because members are asking so many questions. Members are asking questions, the answers are very limited. And I will go through that statement again briefly in, I'll paraphrase. This being our statement, the Uganda Law Society statement on the unlawful actions of Philip Munabi. He was around. It's unfortunate that he left. I felt probably this should have also been an opportunity to have an engagement, a proper engagement, because if our intentions are clear, then they should really be clear to serve the benefit of the society. So as Uganda Law Society, we strongly condemn the unlawful actions of Advocate Philip Munabi, who circulated a deceptive notice for an extraordinary council meeting on 24th February 2025 without consulting council members. This move is a clear contempt of the High Court decision in Ministerial Cause number 263 of 2024, which emphasizes that the Secretary's mandate is exercised in consultation with the Council. Munabi's actions are part of a larger pattern of behavior that led to his initial suspension from Council and a subsequent criminal complaint against him and his accomplices. We urge the Court of Appeal to expedite the hearing of our appeal to determine the legality of the Council's decision to suspend an errant member pending a decision of the General Assembly. We will continue to monitor the situation and take necessary steps to protect the interests of the ULS and its members. We advise members to remain calm and ignore Munabi's erratic behavior, as he will be held accountable eventually. If you notice, this notice, which was apparently addressed to us, council members individually, was circulated all over social media on a Saturday, purportedly calling for a council meeting on a Monday. We are all practicing advocates. We have work to do. But most important, the court was very clear. Even if we are to enforce, we say we respect court orders. We cannot, someone asked a question, we have to respect what court has ordered. But you also see this as contempt because it's outside what court ordered, what court directed. We believe this is aimed at creating confusion within the membership and creating a state of uncertainty. But I can assure you, I want to assure you that we shall not allow to be taken down that drain. We do serve the membership, we're accountable to the membership, and whatever we do is in the interest of the membership. Now, I also had questions about the president. Jude clearly stated the president has individual lawyers handling his matters, but we cannot again run off from the fact that events have happened that are also making us have so many questions. The members of the public, the members, Uganda Law Society members, asking so many questions. And as you're aware, before the happenings, before all this unfolded, the president had traveled out of the country on official duty. At the time he was in Kigali, right now he's in Zanzibar attending the East Africa Law Society Council induction. And all this happened when he was out of the country. And I must say the happenings are so unfortunate. As you've seen, it is also a pattern which we've noticed since we took over office. It's a pattern that is absurd because we know the bar and the bench must work together for the good of the public, for the good of the country. We cannot work separately. One cannot fight the other because at the end of the day, it's the common person that suffers. Again, as the bar, we also, I'll stress what my colleague Jude stated, we must fight for the independence of the legal profession. All these laws, the ULS Act we talked about is an act of 1956, everyone has talked about it. I think the time it came into force, there should have been around less than 100 lawyers. Right now, we're over 6,000. I've been presiding over an enrollment process today where 300 members are coming on board. Now, if we fail to have a proper way of resolving our affairs at this stage, if we cannot protect the independence of the legal profession at this stage, what will happen in the next few years when the members are 3 times the number we have? So as Uganda Law Society, we do condemn the actions, or what I would call the persecution of the president, Uganda Law Society, trying to send a message, because I believe this message is being sent out to all the members, not just one individual. This is a message that is being sent to all of us, that we can handle, we can take care of you. We can manage you, we can punish you. And we believe it is affecting not just the image of Uganda Law Society, but also the image of the judiciary. Just, I think yesterday, I was reading a post by, a member of the public, someone who says they do not understand law. They are not very well educated. But by the time this person has noticed that there is a fight between the bar and the bench, and he's saying if judges and lawyers cannot resolve their disputes, how can we trust them with our disputes? And this lady says, I'm actually very worried. That's why I said the image it sends out there is very bad. We need to look inside our hearts and we resolve this, because it doesn't only portray the bar or the lawyers generally in a bad picture, but also the bench, because people look at us with hope that we are going to resolve their disputes. We are always preaching to them certain things like mediation, out-of-court settlement, and then they see us seemingly fighting, which is really absurd. And to that effect, I do have also our statement regarding the president, the status of the president. And this, it's titled, the Uganda Law Society condemns latest arrest warrant against President Isaac Ssemaka Day. And it is dated today. the 27th of February 2025. The Uganda Law Society strongly condemns the Uganda Road Chief Magistrates Court decision to issue another arrest warrant against its president, Isaac Ssemaka. This warrant, issued on Monday, 24th February 2025, is the second in less than 2 weeks, following a similar warrant issued by then High Court Judge Musa Sekana on 14th February 2025, which Jude called the Valentine's gift to the Uganda Law Society. We view these actions as a blatant abuse of judicial power and a continuation of the ongoing judicial harassment of our president. Despite the Uganda Road Court's awareness of the President Ssemaka's ongoing revision application in the High Court of Uganda, challenging an earlier ruling by the Chief Magistrate, Ronald Kaizi, the lower court chose to ignore these developments and still went ahead to issue a warrant of arrest. Like I said, the second one in less than 2 weeks. The ULS is deeply concerned that the judiciary is being used as a tool for persecution rather than upholding the rule of law and ensuring justice. We urge the High Court and Court of Appeal to expedite the hearing of our President's corrective actions and put an end to this blatant abuse of power. We call upon all stakeholders to join us in condemning this judicial harassment and to stand in solidarity with President Ssemaka and the ULS. Today, it is President. The next date could be you. The next date could be me. All we are saying is judicial power should be used to serve the interest of individuals and to promote the rule of law, but not to punish or to persecute individuals. That is our statement. I thank you all for listening to me, and thank you for coming once again.
To our weekly Radical New Bar Live press and public engagement. This is the 7th series, and we are going to, Council MCC is going to speak about grievances and concerns, and he will tell us from where he's coming from to speak to us about those concerns and grievances. Then we have Councillor Jude, who is going to give us an update on the cases in court. Councillor Jude is the one who represents our Uganda Law Society, all the cases that have been happening in Uganda Law Society since November last year, and assisted by our own Councillor Mariam Nansuksa of Legal Aid. Councillor Nansuksa will not speak today, but Councillor Jude will speak to us. You are all welcome. Thank you. I take this opportunity right away to invite Advocate Musisi George to come and take up the podium and address us. Thank you.
Thank you, Madam CEO. Good afternoon, ladies and gentlemen. The Vice President, members of Uganda Law Society, council members present, our colleagues from the media, ladies and gentlemen. My name is George Musisi, as Christine has rightly introduced me, and I represent the National Unity Platform as a legal advisor, counsel, as a legal representative in many matters. I was asked to speak to some of the issues pertaining, and I will restrict myself to the legal issues. And we know that the National Unity Platform has made news for the last 1 week, but I want to stretch it to the last 10 days. If you discount the events that happened yesterday when our candidate for the Kawempe North by-election was being registered, by yesterday we had 10 people, that was before yesterday, abducted by security agencies. I deliberately use the words abduction to the chagrin of the the government spokesperson, Honorable Chris Bariomos, who has told me several not to use abducted, because I know an arrest is defined under our laws. And we know that even our constitution lists down the pre-trial rights, the procedural steps to take when a person is being arrested. Very basically, you are supposed to tell me why you are detaining me. You are supposed to tell me the charge. You are supposed to take me to a gazetted place. You are supposed to allow me access to next of kin or lawyer or even medical services of my choice. All that, those are constitutional rights. And if at all you are to detain me, you are not supposed to detain me for more than 24 hours. You're supposed to produce me before a court of law. Where people dressed like my brother Adam here, but armed, these days also masked, come and arrest me in an unregistered car, take me to an unknown place, don't tell me why I'm being held for several days, that cannot be defined as an arrest. So those are state-sponsored abductions. So we've had 10 people abducted in the last 10 days. Only 3 of them were only yesterday charged formally before the Chief Magistrate's Court of Masaka with aggravated robbery. Even these 3, I had a chance, they were arrested on last week on Thursday and kept in a gazetted place at CPS, Central Police Station, Kampala. And even when I met them on Monday, I was told the charge was something to do with unlawful drilling. Until they were driven that afternoon to Masaka and were charged with aggravated robbery of events which purported to have happened sometime in May last year. But at least now they are charged and they're in an unknown place. The other 7 have all been released. Well, of course, we had filed for habeas corpus applications for all of them. And the first application to came up on Monday this week before the High Court. And the state asked for one more day to consult its state agencies. And then they were all released. And the release itself was by the same security who have been holding them, driving them to a police station and telling them, you go home. Out of the 7, only 2 were given bond papers. Others were just released, that you just go home. Actually, one of them was not even dropped at a police station. One of them was just dropped at a place about 100 meters away from his home. But all these were in state detention. All of them were in the custody of what used to be called at CMI. I know it has a very lengthy name now, but the same premises. And of course, all of them bear the same story, that we are taken, hooded, detained, tortured, beaten. Of course, the torture is now through beatings. But I want to relate the last 10 events to what has been happening the last almost 4 years. Many times we want to leave a record. So we've been to the High Court. We've filed over 50 habeas corpus applications before the High Court in the last 5 years. All those things they call for the drone attacks. And the standard has been the same, that we either, sometimes they would even first hold you for a month. If we don't go to court, they don't release. Until when the matter is coming up, or when the court is very angry towards the state attorney, and the state attorney makes the relevant calls, and then they are released just to defeat, or they are charged. Very few have been charged. Most of them have been released without charge. So it's an abuse as well, and this is where I would call upon courts, because the laws are very extensive, and like it happened in the case of Dr. Kizza Besigye. It's not enough for you to say that now the person is here. Now the habeas corpus has been overtaken. I think court has a duty to interrogate this detention and make other orders. Yes, you've now released him, but in which custody has he been in for the last 1 month or for the last 10 days? And that's a chance we always lose from courts. Because even the Dr. Kizza Besigye case, I felt that court should have pronounced itself on the legality of the detention between 3rd, when the warrant expired, to the day when he was produced in court. So, because as it is now, it doesn't send a deterrent message to these agencies. First of all, these people are lucky that they have a lawyer who will go to court and file an habeas. It means that if there's no lawyer filing habeas corpus for you, you can remain there. And indeed, there are stories of people who have remained there. It also took us to the issue of the siege, abductions aside, or raid, which police called a search as well. I also prefer to use my words very deliberately because a search is a legal issue. Any search of a premise should be, for it to be conduct any bit of lawfulness, it should have some minimums. If you are to search, I was talking to the government spokesperson, Honorable Mr. Fonopondo, on Saturday, and he told me that he has information that they had an ex parte warrant from court.